Welcome to Ask a Lawyer. Today I'm talking with Lance Avera of Avera and Smith. And Lance, I'd like to ask you about a concept that's becoming increasingly popular called employee leasing. I don't think that employers or employees are real straight on all of the parts of that concept. Can you help us out?
Linda, in Florida, in other states, in the United States, there are companies that are professional employee organizations. And what they do is they provide a service for smaller employers, and the service is usually payroll and insurance benefits for their employees. And the leasing company, or the PEO, Professional Employee Organization, they have a broad base employees, say 50,000, 100,000 employees. So when they sign up or take on insurance through whatever carrier, they get a reduced rate for insurance benefits, and they provide the payroll for the employees. And how it works is a company would have their employees apply and become employees of that PEO. And the company would lease them back as leased employees. There can be problems with that PEO in that when employees when they fill out the application, they go through the application process, they are not effectively an employee of that professional employee organization, the PEO, until the application is processed.
So they're sort of in limbo for that period of time?
Yes, they are, and there's some case law that has come out that effectively states that they are not an employee of that PEO until their application is processed. So if the company, the contractor or whomever that is using the leasing company does not have a workers' compensation policy in place and they have not been accepted as employees with the PEO, then they are not covered by workers' compensation, sometimes for days, weeks, or several weeks until that application is processed. The problem is if an accident happens the first day on the job, first week on the job, there is no coverage for that employee.
And the employee, the employer are maybe assuming that they're covered because the employee is supposed to be working for this organization.
Absolutely. The employers, typically the contract would read that the employee does not become an effective employee of the PEO until the application is processed. What happens is the company starts them earlier and does not wait until the application is processed. And that creates a gap of coverage for these employees. And it creates corporate liability against the company that is using them. And if they are a subcontractor with a general contractor over them, it creates corporate liability for the general contractors as well. So it is a problem in the law involving professional employee organizations in the state of Florida.
So what could a contractor do to avoid that problem? First of all, become aware of it. I think that we're doing that in the show, educate them.
Right.
But after that, what can you do about it?
The company that's using the leasing organization needs to wait until they've got confirmation that the person has been effectively accepted as an employee. That's typically with an employee ID number. In other words, the company's provided an employee ID number. Once they have confirmation that they are an effective employee of the PEO, then they have coverage that's in place that would protect them.
So their paychecks are generated from this other organization?
That's correct. The payroll goes through the payroll goes through the professional employee organization.
And this also is health insurance as well as workers' comp?
If health insurance is offered, it can be offered through the leasing organization as well as the workers' compensation coverage as well.
Is it a big monetary benefit to an employer to do this? Is that the attraction?
Well, with the construction industry and other companies that have high premiums for workers' compensation, it is advantageous to have a leasing company in place. So it can provide them a break in premiums for workers' compensation coverage, and it can provide them a break for medical benefits that they provided to their employees.
So there is a benefit to doing this, but there's also drawbacks. And have you handled any cases where they've had to deal with the drawbacks?
Yes, we have. We have had cases where the company did not wait for the application process to be finalized, and that the employee came to us and there is no coverage in place. The company did not have a minimum premium policy in place that would protect them and protect the employee. And the leasing company has said, well, we haven't processed their application, therefore they're not our employee yet. Then you have to look at other avenues of insurance coverage, and this happens when you have catastrophic injuries or significant injuries and the employee is sitting there looking for someone to help them pay for their hospitalizations, their medical bills, and their lost wages while they're recovering from those injuries.
So the advice is whenever you have any kind of a contract to sign, bring it to an attorney, particularly one like yourself that specializes and is board certified in this area.
My advice to the employers that use the leasing companies is to read the fine print of the contract, to find out exactly when the leased employee becomes accepted as a leased employee with the professional employee leasing organization or the leasing company. Do not use those employees on your work site or job site until you have gotten confirmation that they are covered. And if you can obtain a minimum premium policy to protect your corporation, I would advise doing that as well.
Thank you, Lance. Good information.
Thank you.
And we'll be right back.